Hey guys, welcome back. Today, we're diving into 5 wild courtroom cases featuring 5 very different sovereign citizen disasters. 3 are familiar faces with major updates. 1 is a self-proclaimed American national convinced the law doesn't apply to him. And the last is a Karen who refuses to participate in her own custody hearing, even as it costs her time with her children. And yes, I was right. His stupidity wasn't completely random. It was calculated enough to land him probation on multiple charges, including a level 5 drug felony. So buckle up, because things are about to get wild.
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's
don't
never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
On the second.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's
Oh,
to advise you of why you're here,
okay.
what your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a
Okay.
bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the, we'll file it in the file.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
Yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well,
a little over a year ago.
Okay, so I'm gonna go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll
Yeah, sure.
be around and be available for you, okay?
Yes, ma'am. I'll take counsel, no doubt.
All right, thank you, sir.
Okay, thank you.
And that's the first sovereign citizen wrapped up, a textbook case of self-sabotage. He talked his way into a surprisingly generous plea deal, then completely blew it by never reporting to probation. Now that probation has been revoked, the safety net is gone, and he could be heading straight to jail. But we're moving on because the next hearing gets even crazier. This one involves Albert Hicks, one of the most aggressively confrontational sovereign citizens I've ever covered, and the second he starts talking, it's obvious this courtroom is about to go completely off the rails.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hemmer Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't practice to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm
Okay.
challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks?
I'm
You want a
challenging-
trial? You want a trial date or you want the
I'm
offer that's in the
challenging
file?
jurisdiction. I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to
Write it
put it
up.
in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have
Okay.
delegated authority to do that.
Okay. All right, well,
I'm
trial
challenging
date,
jurisdiction.
trial date, I'm denying, what is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so,
Honor your oath of office, please. Honor your oath of office, okay?
are we going to sit here and debate those
It's not a
positions?
debate. It's my constitutional right. It's my constitutional right.
You think so?
I
Okay,
know
so,
so. Are you violating my constitutional rights on how you deem them to be?
no, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a
Please.
transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you gonna do today, Mr. Hicks?
Challenge jurisdiction
And how are you challenging that?
because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case,
Okay.
and I deny that motion.
Why you
If
denying
that-
the motion? Because you don't have.
Even
You don't
if
have.
that is, so Mr. Hicks, you're a grown man. Let's have a few seconds, wait a minute. Let's have a few second conversation, okay? Now,
Okay.
let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying, no, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion.
Beautiful.
Okay, let me ask you this. What
Beautiful.
basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I
Right.
told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two
As a
options.
matter of fact, hold on, give me a minute. You
Go
even
ahead.
went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks.
Mr.
Let's not go there, all right? Did
Do you have
you
the
say that
transcript?
last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about
You don't
that.
even have a
I
license
thought
to
about that.
practice law.
Listen, this
You
whole,
don't have a license to practice law. Come on, the jig is up.
all right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now, I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can, okay, don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got
Don't
your
talk.
paperwork ready. I got your paperwork ready. You really
Don't talk.
You
There
really
you go
want to do
again.
this?
All right. Now, I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course I do.
No, you don't, and that's exactly where his entire argument falls apart. The court makes it clear. The Constitution guarantees the right to a jury trial, not the freedom to switch between a jury and bench trial whenever you feel like it. It's basic law, and any competent attorney would know the difference. With that argument completely exposed, we head to the end of Judge Perkins' docket, where Mr. Hicks is finally about to find out how all this defiance is going to affect his remaining charges.
All right, I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out, or at least mute yourself. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SP 1442547 counts 1, 2, and 3, SP 144-27651, and SP 5008721. I'm only dealing with those matters. And the officers are not here. So we're going to make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this. I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm going to dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
I know some of you won't like how this one ended, but hear me out. I'd rather live in a system where guilt has to be proven beyond a reasonable doubt, even if that means a few guilty people slip through, than risk punishing innocent people. But don't worry, We're not done with Albert Hicks yet. I've got another clip from Judge King's courtroom involving a domestic violence case with his longtime partner and the mother of his 2 children. Watch his reaction closely as she takes the stand during the probable cause hearing. His facial expression says a lot.
Is that Albert Hicks?
Yes.
Okay, and how do you know that person?
He was my partner, and he is the father of my children.
Okay, how long were you guys partners for?
Around 14 years.
And now the witness is actually showing up, which changes everything. Hicks may have walked away from today's charges, but his fantasy of unrestricted, unlicensed travel is quickly running out of road. The consequences are no longer hypothetical. From there, we head to Washington, where we meet a so-called American national who genuinely believes declaring a status puts him above the law. As you're about to see, reality has a very different lesson waiting for him.
My honor. So, for the record, I've made this special dissertation under duress pertaining to the matters of Jonathan Troy, Faifa Leaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality? And what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last 2 are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I challenge the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued.
What is it with sovereign citizens and their obsession with threatening to sue everyone in the courtroom? Judges, prosecutors, even their own court-appointed attorneys aren't safe. Some will threaten a lawyer simply for stating their name on the record. It's gotten so extreme that even a retired Michigan family court judge has publicly backed measures aimed at protecting judges and their families from harassment. When the people enforcing the law need protection from non-stop intimidation, you know this movement has completely lost touch with reality.
This is not personal to me that these situations happen. I was a presiding judge of the family court for 8 years. These are conversations I have with my colleagues on a daily basis, talking about how sovereign citizens file UCC statements against us, against our property. We have to have lawyers in our court represent us to remove these filings against us.
So yeah, threatening to sue the judge is probably the fastest way to wreck your own case. It's not some clever legal move, it's a self-inflicted disaster. All you're doing is showing the court that you're unreasonable, uncooperative, and not someone it can trust. And once the judge sees that, forget about a PR bond or simply walking out of jail. Instead of gaining leverage, you've just talked yourself into staying locked up longer, all because you decided to play pretend lawyer.
It would just add to that. And I don't think that you need to go that route.
While I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the
Unless you
law.
want to enter a plea of guilty, today there'll be a plea of not guilty. I understand you are objecting.
Ma'am, I
to-
object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-US citizen, American national by way of American Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
Jurisdiction isn't some magic word you can throw around to derail a case. It's established by law and supported by evidence. Once the state shows when, where, and under what circumstances an alleged offense occurred, simply shouting no jurisdiction doesn't make it disappear. If you want to challenge it, you need actual evidence, not slogans, theories, or recycled courtroom scripts. In other words, the courtroom isn't a game of magic words. Facts and evidence are what matter.
all right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating
Again,
the laws.
I was not driving. Again, I have rights.
You were
And
behind. the
my
wheel.
rights were
Your eye was
violated.
traveling.
My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am
you.
sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
You expect the court to believe someone is less likely to reoffend while openly claiming its laws and jurisdiction don't apply to them, and then threatening to sue the judge when she proves otherwise? That's a massive red flag. When someone rejects the court's authority and refuses to accept basic legal reality, it's reasonable for the court to question whether they'll follow conditions or orders. From the judge's perspective, that attitude alone sends one very clear warning. This person may be back in the same courtroom sooner than anyone wants.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also indication that Mr. Schuster will not abide the court's orders to appear on his promise. Want to look at the Seattle municipal case and see when he's next scheduled to appear.
Like you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Malietoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I've had to learn a lot.
Well, I guess all those previous court appearances were wasted because you clearly learned nothing. The biggest point is this. When you previously pled guilty and accepted a deferral, you acknowledged the court's jurisdiction over you. You can't spend years claiming the court has no authority while happily benefiting from the same system you reject. That contradiction says it all. This isn't confusion anymore. It's a deliberate refusal to accept reality.
And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the Seattle case.
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me, I can't be swayed by that. So
it's not a threat. It's just what it is. Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
when are you setting that court date, Miss?
Required by the Department of Licensing. You are, you will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
These are criminal charges that have significant consequences for you. So it's in your best interest to have counsel.
Again, I stand on my own 2 feet. I do not need to be represented by anybody. I present myself sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
All right. The time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be on June 24th. That's 2 weeks out.
So for the record, you have not established status, you have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench. You're asking me to sign something that you pleaded for me. Is that correct?
I'm giving you notice of the conditions that I have set as well as bail.
You said yes, you pleaded for me?
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice, and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a
I
piece
do
of
not
paper
understand how
with
you can
the
practice
document?
law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty. So on your behalf, I'm entering a not guilty plea.
So correct, you are pleading for me,
There's
correct?
2 pleas.
And if you
Not
plead
guilty
for me,
or
you're
guilty.
practicing law from the bench. You cannot practice law from the bench, so I object. That
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay? All right.
Jennifer Grant, you will be
Okay.
taken further.
Poor guy. Nobody took him seriously, and now the punchline is that he's heading straight back to jail. With that chapter closed, we move on to a familiar face, Eric Martin, a sovereign citizen who's appeared on this channel and plenty of others. Usually it's routine traffic tickets and minor nonsense, but this time the stakes are much higher, the charges are far more serious, and his usual courtroom antics may not be enough to laugh this one off.
And then we've got Mr. Martin.
He claims to be an attorney, so he refused to speak with Mr. Fanto.
I'm looking forward to it. All right, this is 241388, the state of Michigan versus Eric Joseph Martin. Sir, can you tell me your name?
Oh, not the Roman Sesticate Trust, if that's what you're wondering.
Okay. Are you going to tell me your name or not, Mr. Martin?
I just want to make it clear, I'm not the legal fiction corporate entity defendant.
Okay. All right.
If I give a
Sir,
name.
if you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please let the court know immediately. You are here today on count 1, domestic violence. There's an allegation that on June 8th of 2024 in the city of Taylor at 9074 Clippard, that you did make an assault or an assault and battery upon Crystal Nicole Martin, a resident or former resident of your household, contrary to MCL 750.81 parent 2. This is a misdemeanor punishable by up to 93 days in jail and or $500. A consecutive sentence may be imposed under MCL 750506A if the assault was committed in a place of confinement. Those are the charges against you. You've been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty, not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered, and you may plead no contest with the permission of the court. You have the right to a trial by a jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, meaning you cannot afford to pay for an attorney. If the offense requires a minimum jail sentence, this charge does not have a minimum jail sentence. The court determines that it might sentence you to jail, and the appointing authority, which is the court, would decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of the appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must then determine your ability to pay. Mr. Fanto, a court-appointed defense attorney, is present in the courtroom. It's my understanding he attempted to meet with you, and he was was advised that you did not want to speak with him. Is that correct?
Because of the unfairness of the laws that would fraudulently assume if I take a lawyer that I would be giving up my right to be one of the sovereign people and be fraudulently assumed to be a legal fiction defendant. Yes, I
Okay.
None of that made any sense. Calling yourself a sovereign isn't a legal status. It's based on a fundamental misunderstanding of how the legal system works. And accepting a court-appointed attorney doesn't somehow change that. You can't claim the law has no authority over you while relying on a lawyer provided by that same system. That contradiction doesn't strengthen your argument. It only makes the whole act look even more disconnected from reality.
I have refused that a lawyer
Mr. Martin,
fraudulently
Mr. Martin,
represents me.
if you have a trial, you have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court to require those witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you will give up the rights that I just listed to you. You also have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or a finding of guilt is made by a judge or a jury, it may result in a violation of your probation or parole. The court can sentence you to jail and fines plus cost. And the court must tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, and both, which I've already done. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, you can contact the court immediately and request a payment alternative. So those are your constitutional rights going forward, Mr. Martin.
I want to make it clear I have been illegally arrested here by Barbara, okay, because he just went by her lies saying I kicked her. As soon as he walked through my door, I'm the one that called 911 on Crystal Martin, okay?
And what kind of twisted logic says the police have jurisdiction over your sister, but somehow not over you? That argument falls apart the moment you say it out loud. You can't selectively recognize authority when it's convenient. Either the law applies or it doesn't. The second you admit it applies to someone standing right beside you, your entire argument collapses. At that point, it's not a legal theory. It's just personal fantasy dressed up as principle.
All right, sir, you have a constitutional right to remain silent, and anything you say with respect to this case could potentially be used against you in a court of law. So I would advise you at this time to remain silent with respect to the actual facts or allegations listed in the complaint and misdemeanor complaint, which I've read to you. Sir, are you gainfully employed?
Well, I wish to finish before I answer your questions. I will answer your questions. I want to finish exercising my First Amendment right, freedom of speech, and continue what I was saying.
Okay, sir, you are to appear in court as directed. I'm not going to argue with you, Mr. Martin. I understand your sovereign citizen argument. It's not the first time I've seen it or heard it. You are under the jurisdiction of this court. This court has jurisdiction under the Michigan Constitution and the laws of the state of Michigan. You are charged with a 93-day misdemeanor, sir. You've been advised of all of your rights. Okay, you have a First Amendment right, certainly, but you are here for an arraignment, not to lecture me on sovereign citizen beliefs, okay? I'm trying to get you through this and make sure you understand the process. You are to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with the complainant, Crystal Martin, in this case. Do you understand me?
Well, I do not understand in that I do not stand under the charges, the false fraudulent charges, but I do comprehend. But as I was saying, I was illegally arrested in violation of my due process rights. There's not sufficient evidence for my arrest that I did any domestic violence. Barbara just arrested me anyway. There's no video of me assaulting her. He did not see it. She just told a lie. I actually
Sir,
filed a
do you
PPO on her.
Sir, do you understand that they have no contact with Crystal Martin?
And then you need to tell her, do not come to my house. She keeps coming to my house so she can set me up with these lies because my sister can't let her over. I want to contact her, but she needs to stop coming over to my house. You know, I've been living there for 33 years.
Miss Maudlin,
Let me finish talking. I have the first right here to talk.
Mr. Martin, it's clear to me at this point that you have no respect for the court. I believe that you're a danger. I can't get any information from you as to whether or not you have another place to reside, whether or not you understand the court's no contact provision. I need to know that you understand what I am telling you, because I am attempting to set a bond on your case. And if you want a bond on your case, you've waived your right to an attorney. And I'm trying to figure out, do you have another place to stay? Do you understand what no contact means? And if you're not going to express to me that you have an understanding of what I'm saying, and if we can't get on the same page about that, then I'm inclined to not give you a bond. Do you understand me, Mr. Martin?
I comprehend you, yes.
Okay, do you understand that I said you were to have no contact with Crystal Martin?
Yes, but she needs to stop coming over to my house. I'm not trying to contact her. She's coming over to my house so she can make false allegations like this, set me up so she can have the whole house to herself, her and my sister.
He could have simply said, "No, Your Honor, I don't understand what no contact means," and saved everyone the circus. Instead, he launched into another performance that only dug the hole deeper. It really makes you wonder what kind of sovereign nonsense he put his ex and even his own sister through, to the point where they had to unite just to keep him away from the family. When your own relatives feel they need to protect themselves from you, that speaks louder than any courtroom script ever could.
This is what the whole agenda is of her with my sister. Lisa Martin tried this before. Even though I proved to the court before the video of my sister Lisa Martin trying to set me up with lies and try swinging at me, assaulting me. I have this on video, saying with Crystal Martin here. I have her on video swinging at me and dealing with the prior case she tried to bring me against. Okay.
So,
I have evidence that she's aggressive towards me.
Mr. Martin, does Crystal Martin live at the home on Clifford Street?
Yes, she comes over like for a day or two, and my sister lets her come over, and she stays there for a day or two. Yes, and then here and there.
Okay, so your sister owns the home.
No, she doesn't own the home thing. So my understanding is the bank really owns it. It's always been like my parents' house. But I don't even think really my parents own it because they didn't finish paying off the mortgage or whatever. So I think technically it's the bank's house, but me and my brother and sister have been staying there for a long time. Me there for like 32 years. My parents have passed away now. So now it's like a fight with them two. They're trying to take over the whole house by coming with false allegations, by telling cops, "Oh, he assaulted me," all the time. There's no evidence. It's not true. It's a lie. There's insufficient evidence in violation of my due process rights. But Bartaway arrested me anyways, and this is just what she wants, so they can have the whole house to themselves. I even filed a case on Crystal Martin.
All right, so you're not to have contact with Crystal Martin. You're not to return to 9074 Clipper in the city of Detroit, or in the city of Taylor. I'm sorry. You're allowed.
Objection, it violates my due process. You cannot deny me my right to live at my house because of an unsupported allegation by her, which is a lie at that. Like I said, the cop had no sufficient evidence. She just told a lie, and the guy didn't even, Bartaway, that is, the police officer, just came to me and arrested me right off the bat. That violates my due process rights with sufficient evidence.
Sir, you're allowed one visit to the premises to obtain personal belongings. You must be accompanied by a police officer.
And I want Bartaway. Well, hold on, I'm gonna let you finish. I'm just gonna finish what I got to say, so you don't cut me off. And I want Bartaway arrested for his illegal arrest. I want Bartaway arrested for illegally arresting me. I want him charged for assault and battery, for illegally arresting me, and kidnapping.
Okay.
Because it was without my consent.
Mr. Martin, if you are not allowed at the 9074 Clifford Street address, where will you be staying?
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You
Well,
ordered
these
them
other
illegal. That violates
individuals,
my due process.
all right. He has a $2,000 cash bond with a GPS tether.
Yes,
And he's
objection.
not
That
to
violates my right to a
return.
personal bond.
He's
I have a
not
constitutional right that
to
you said
appear
you
at
can be good
9.
innocent without guilty.
He cannot come to 9074 Clifford or be in contact with Crystal Martin.
All right, that's the end of that hearing, and honestly, I've had enough of this guy. He's pretentious, painfully monotonous, and somehow convinced he's the smartest person in the room. Yet he still ended up exactly where he was headed. Now we move to the final hearing of the day, and this one takes a completely different turn. A sovereign citizen, Karen, caught in a custody battle who somehow convinced herself that she, not the judge, was running the courtroom. And as you're about to see, that illusion is about to collapse fast.
All right, now we're going to move to Habib versus Bouvier. All right, so remember when we last came on this matter, there were some issues that had come up that the court was not quite aware of. I think it may have been the reports. I had not yet read them. And some of the things that were being said, I wasn't familiar with. So I asked everybody to come back so that I can read through those reports and have a better understanding of the backgrounds of everybody. And so I've had a chance to.
Your Honor?
Oh, okay. Give me. So the court had an opportunity to review those and has a better understanding of background. I can't remember exactly how far we got in there. I don't know if Ms. Giles even made recommendations at that time. I don't think we got that far, but I'm not sure if you all remember or not. But I have read the recommendations in the report.
I don't think we got that far last time, Your Honor.
Okay, all right. So the let's see. So since I have that background, let me start by calling Ms. Giles. Raise your right hand. Please tell me swear or affirm testimony about to give in the case is the truth, the whole truth, and nothing but the truth to help you God.
I do.
All right, and if you would, we have Ms. Bouvier. Ms. Bouvier, you need to turn your video on because we're in the middle of middle of the hearing now. So you have to have your video on. You turn your mic off, but your video needs to be on.
Your Honor, for the record, before we proceed this matter, there are some facts I must state for the record. I'm here on special restricted appearance as the representative of the descendant. And I do not wish to waive any rights, rather statutorial or procedural. And for the record, as the authorized representative, executor, beneficiary, I have demanded a jury trial in regards to this matter. Moving forward, for the record, Your Honor, I have filed an amended notice of recusal with an affidavit of fact on May 29, 2024. With all due respect, Your Honor, I have not received a response from you in regards to this notice. Please note for the record, I have presented to this court on special restricted delivery all presentments to date. Moving forward, according to Georgia Code Section 1512-122 and 2020 Georgia Code Section 91138, rights to a jury trial is a reserved right.
Sure, but that argument goes nowhere in a custody hearing. These cases are handled by the judge, so there's no jury trial workaround, magic phrase, or sovereign shortcut. And this is where things get serious. She's putting her sovereign beliefs on one side and custody of her own children on the other, and choosing the beliefs. When someone lets an ideology come before their children, the court doesn't have to look very far to see where the real problem lies.
Please note for the record, at this time, I do not wish to add nor subtract anything from my presentments, and I stand behind my documents. And at this time, I respectfully excuse myself from this proceeding to await all notices concerning the trial by jury according to the law.
Okay. So first, you filed a motion for recusal, which the court denied. Looks like you filed, you need to turn your video back on. If you don't turn your video back on, I'm going to have a hearing without you. Okay, so turn your video back on. All right. You filed a motion for recusal, which the court reviewed and denied without there being sufficient evidence. I think you filed an amended one, which the court did not receive a copy of. You were supposed to send that to Chambers if you actually wanted me to respond to it. But you filed it via e-file. I'm noticing it now. It's going to be denied for the very same reasons. With regard to your request for for a trial, this is a custody matter. It cannot be a trial by jury because you can't have a trial by jury on a custody matter. So that issue will be denied. As for your representation, the court will consider you London Bouvier. That's who you are. That's what the court consider you as. If you want to consider yourself as anything else, that'll be up to you. But when I make a decision, it's going to be for your government name, London Bouvier. And that's what the law of Georgia is going to hold accountable. So when you don't do what I asked to do, your representative or whoever you think you might be won't be going to jail. It will be you, London Bouvier. Okay? So I want to make sure you understand that. So is that clear to you? All right, we're going to proceed in these proceedings. If you want to participate, that's up to you. If you don't want to participate, that's up to you. But I am going to make a ruling, and the law will be what the law is. I suggest you should participate so that you can be heard and that the concerns that you have, the court will have an opportunity to hear them. That'll be up to you. Okay?
I actually appreciate how the judge handled this because she did exactly what the process required. She gave Karen a fair chance to identify herself, and Karen deliberately refused. The judge didn't argue or play along. She simply made it clear that the court knew exactly who was standing there, and the hearing would continue anyway. No theatrics, no validation, just a firm reminder that the courtroom doesn't stop because someone throws a tantrum.
Has this order been followed? Is it being
No, Your Honor, that's why we're here.
It's not being followed.
No.
No, right. We filed a contempt on this order on May 7th.
Really? I had thought that this matter was coming back on the calendar because I continued it from the last matter, but now I understand. Okay, so there is also the contempt on the interim order.
That's
all right.
correct, Your Honor.
Got it. I got it. All right. Yeah, all other issues shall remain. Okay. All right. So the order isn't being followed.
That's
It is
correct.
not.
That's the issue. It being followed at all, like no visitation or just being
No visitation at all, Judge.
all right, Ms. Bouvier, I've indicated to you once before that your video has to stay on. This will be my last warning to you. Turn your video on. Ms. Bouvier, if I say it again, I'm going to find you in contempt of court. If I say it again, I'm going to find you in contempt. So when any issue happens before, I'm going to have my deputies come get you. Okay? You turn it off again, I will find you in contempt of court. All right? So you will spend 10 days in the DeKalb County Jail. You turn the video off again. Okay? Did you understand me, Ms. Bouvier? Did you understand me, Ms. Bouvier? Unmute yourself and say so. Ms. Bouvier, I'm going to ask you one more time. I'm going to excuse you from this hearing. I'm going to find you in contempt, and I will pick you up. And your child will then go to Mr. Habib. Unmute.
I stand behind my documents. For the record, I stand behind my documents.
You can stand behind whatever you want. Do not unmute like I asked you. Ms. Marshall, go ahead and remove Ms. Bouvier from these proceedings.
Yes, ma'am.
I find you in contempt of court. 10 days in the DeKalb County Jail. Child will be presented to Mr. Habib. These matters will be continued thereafter.
And just like that, Karen managed to put two major barriers between herself and her kids. 10 days in jail and temporary custody handed to their father, all because she refused to participate. Once she's released, it'll be interesting to see if reality changes her priorities. That's it for today, guys. This was a long one, but I hope you enjoyed it. Let me know what you think of these longer videos in the comments, and if you enjoyed this one, hit like, subscribe, and I'll see you in the next video.